In this installation of our discussion of school law and policy, we are going to focus on the legal implications of serving students and individuals with disabilities. So the legal overlay to all this actually started in the 70s with the Education of All Handicapped Children Act, Public Law 94-142, as it was called in 1972. That law was replaced in 1990 by IDEA, or the Individuals with Disabilities Act. And of course, that law was reauthorized in 2004 as the Individuals with Disabilities Improvement Act. And all of this legislation essentially guarantees that a disabled child ages 3 to 21 the right to FAPE, a free appropriate education in public schools. The Act establishes substantive and procedural due process rights for students that have disabilities. There are two really foundational cases that I want to start with, and the two cases are the Mills v. Board of Education and the Rowley case. The Mills case was a landmark case that addressed whether a school district was required to provide facilities for behaviorally disabled children. The district responded affirmatively in stating that a school district must provide facilities for these students. The court fashioned a lengthy order that mandated special education programs and outlined a lot of what eventually became the law. The lack of funds was no excuse and was not supported by the court. And so the points of emphasis in this case: no child who is eligible for public education can be excluded from education by any rule, policy, practice of the Board of Education or its agents. The school district's failure to provide educational opportunities for special needs children cannot be supported with an excuse by the district that no funds are available to do so. No eligible child can be excluded from receiving FAPE, and due process requirements must be met before any student with a disability can be suspended or expelled. Such actions constitute a change in placement, which triggers full due process provisions. The second case is the Board of Education of Henry Hudson School District versus Rowley. In this decision, this case, primary issue arose as to whether the Education of Handicapped Act, the original public law, required special services sufficient to maximize a handicapped child's education comparable to that of a child without special needs. Rowley was virtually deaf when she was admitted to kindergarten. She was provided a hearing aid, which allowed her to achieve a degree of success. The board subsequently refused to honor a request for sign language interpreter. A suit was filed in district court alleging that Rowley's educational opportunities could not be maximized without this interpreter. The court held for the school district in this case and stated that the Handicapped Act did not require special services sufficient to maximize a disabled student's educational level comparable to a child with no disability. What that means as far as this case is that the Act provides that special services should be provided only when necessary to allow the special needs student an opportunity to benefit from instruction. There was no language in the Act that suggested the benefits are maximized for special needs students. So this Act was designed with the intent to create equal educational opportunities. Since Rowley experienced success without an interpreter, the Board of Education met its duty under the legislation. So looking at the 6 characteristics of free appropriate education that came from IDEA, the 6 parts of IDEA, the first part was actually the child find, which is, the December child count that you're probably familiar with in your schools. The second is the non-discriminatory evaluation of these students using testing and prescribed measures for identification and evaluation. The third is the FAPE that is based in the individual education plan of a student that we'll talk about in a moment. The fourth is the least restrictive environment, which we'll also talk about. The fifth is the procedural due process provision, and the sixth is the parent and student of age participation in this process through the admissions and release work. So the IEP, at minimum, each of these plans should include these 6 elements: the statement of the child's level of performance, their annual goals and short-term objectives, the specific services, which we'll talk also about in a moment, the description of transitional services if needed for students that are in junior, senior high school as far as when they leave this environment, the description of services with a timetable, as well as the explanation of relevant criteria and procedures for annually determining the instructional objectives. The equal access to assistive technology for disabled students is based in this provision, an act in 1994 and the amendments, which provides financial assistance to states to support systems changes to assist the development and implementation of technology support. And so technology is an area that is often left behind in this 1994 provision, looked at equal access when it came to technology as well. So looking at program review changes, each IEP should be reviewed and revised annually, if necessary, to ensure the continuing needs are met. If changes are contemplated, obviously the child's parent, legal guardian are to be notified. If either objects to the proposed changes, then you have to go through the due process hearing to resolve the conflict. If this process proves unsuccessful, the parent guardian may appeal to the state agency and subsequently to the courts if a resolution is not reached. Most of the legal issues that I dealt with in my district superintendency and district work related to these changes and related to the process where the parent and the school committee disagreed on these services, and you have to go through this sort of due process procedure. The education-related service requirement is also something that is a pretty significant provision that has had a lot of different interpretations in the courts. A related service is viewed as one that must be provided to allow the disabled child to benefit from special education. Related service may be a single service or an entire range of services or programs needed to benefit the child. Examples of these services include, but not limited to, transportation, medical services, counseling services, psychological services, physical therapy, speech pathology, audiology, occupational therapy. The relevant case for the service education service related service requirement is the Irving Independent v. Tatro case. And Tatro was born with spina bifida that resulted in a congenital bladder defect, and a clean intermittent catheter was required every 3 hours to empty her bladder. The process was not complicated and only required about an hour of training. When the request was made to provide this service, the district refused by stating that the procedure was medical rather than a related service. The issue that the court addressed was whether the act mandated that the school personnel provide clean intermittent catheter for a student who is in need of this service. The court held for Tatro, stating that this procedure is consistent with the intent of the act and was necessary to promote the access for Tatro. It requires the state to provide appropriate services for children with disabilities, and these services are necessary for FAPE to take place. They viewed the clean intermittent catheter as a simple related service that could be performed by a lay person and ruled that it must be provided by the public schools. So they differentiated between a what we would refer to as a related service versus a medical service that had to be provided by a medical personnel. This simple procedure in this case is something that was competent school personnel could carry out. And so as a result, the court required that they do it. The least restrictive environment is another big area where IDEA embraces the notion that children with disabilities be placed in settings which offer the least amount of restrictions when appropriate. And the primary objective is to provide these children an opportunity to interact, socialize, and learn with regular students and minimize the tendency to become stigmatized and isolated. And there are several cases to look at here. A lot of case law around LRE. The Beth versus Lake Bluff case was a 13-year-old girl with Rett syndrome, which is a neurological developmental disorder. Her motor skills were estimated to be between 5 and 7 months. She began services in special education cooperative at age 2 and received services which included a one-on-one aid, adaptive physical education, speech language therapy, occupational therapy, physical therapy. At her parents' urging, she was placed in a regular kindergarten class with the continuation of services in an early childhood program. During the annual review, again, this is the issue that I just mentioned as far as the disagreements that occur with these kind of decisions that you deal with in district and school leadership. During the annual review of Beth's IEP, the district recommended Beth be placed in a co-op self-contained life skills unit. Beth's parents objected and brought the action after going through all the due process against the district, alleging that Beth was denied a free appropriate education by not permitting her to be placed in a regular classroom. The court held for the district and determined that the district's efforts were appropriate and that it acted reasonably under IDEA in determining the appropriate placement. The burden of proof in this case rests with the school district, where a child with special needs is recommended for placement in special service facility. And the district proved that was the case. Districts will be supported in placement decisions when proper procedures are followed, documentation is provided, which indicate the child with special needs is not well suited for regular classroom. Even so, it's difficult based on divergent views of those considered to be experts. So school districts have an obligation to ensure that a child with a disability be placed in the most appropriate educational environment in order to benefit from their experience. The Schaefer case was a conflict between parents of disabled students and school officials. And of course, these are inevitable conflicts. As we've mentioned, the conflict was heard by the U.S. Supreme Court based on disagreement of circuit court decisions. And the burden of proof was placed on the school district in ruling for the parents. The decision was reversed by the U.S. Court of Appeals. And then the U.S. Supreme Court, in a 6-2 decision, held that the burden of proof in administrative hearings challenging the IEP is properly placed on the party seeking relief. So the ruling by the Supreme Court applied and clarified all these disputes that were occurring over least restrictive environment. And this ruling applies to all districts. The Supreme Court decision brought clarity regarding the burden of proof. Prior to this ruling, there were a lot of wide disparities as far as where the burden of proof should reside. Under reauthorized IDEA, lawsuits filed by parents that are considered frivolous, they assign legal fees, including the cost of the court, to the parents in those cases. But generally speaking, the burden of proof in these hearings is placed on the party seeking relief. So that initially is the parents. Now, in this case, it went back and forth, but ultimately the burden of proof is on the parents was on the parents initially to prove that. The Shaw v. Wiest case is an Oregon student with ADHD and depression that engaged in defiant and risky behavior. Her parents sought a more restrictive environment. However, the district refused based on the fact that the student was earning good grades and did her work and was doing well. The parent placed the student in a residential facility, and she was later expelled for engaging in a sexual act. Her parents subsequently placed her in an out-of-state facility and sought tuition reimbursement. Again, a case that I dealt with where the same thing happened and the parents sought a tuition reimbursement. The Ninth Circuit Court denied the tuition and reimbursement, citing that the student's IEP determined their placement and that the parents voluntarily placed their child in a more restrictive environment outside what was prescribed by the student's IEP, and therefore the costs associated should be borne by the parents. So there's no educational reason that justified that requirement in that new placement. So the student was, or the parents were not given relief in that case. So the case law was very interesting. One of the other areas that's pretty significant in the world of dealing with students with disabilities is the isolation and restraint. A number of states have passed legislation governing this issue and practices for students with disabilities. These laws are to protect the safety and welfare of students. Isolation and restraint laws govern circumstances under which certain measures may be taken, maximum time periods involved, and particular types of isolation that may be used. The laws cover conditions of isolation, rooms, supervision provided, and approval must be granted by school officials prior to initiating this. It's really important as school leaders that you understand that you have a leading responsibility to ensure that teachers are properly trained and cognizant of these isolation and restraint laws. And school officials also have a leading responsibility to ensure that isolation and restraint measures, if permitted, are implemented properly and that the safety of the student with disabilities is protected. You are on the hook. And that's why it's very important that you be very diligent in dealing with this kind of issue. The last group of things that we're going to talk about regarding IDEA is disciplining students with disabilities. And it's long been held that disabled children may not be punished for conduct that is a manifestation of their disability. However, disabled students may be disciplined by school authorities for any behavior which is not associated with their disability using regular disciplinary procedures reflected in school policy. In situations where certain type of discipline are warranted, an effort must be made to ensure that the punishment does not materially and substantially interrupt their education. The case of S1 or Deborah P. versus Turlington involves a group of high school students who ranged from moderate to mild disabilities, and they were expelled for a lot of misbehavior. Deborah P. S1 was afforded a hearing to determine if her disability was related to the offense, and the district ruled that S1 was not seriously disturbed and the disability was unrelated to the offense. Suit was filed on S1 alleging the student's rights under handicap law were violated, and the issue addressed by the court was whether an intellectually disabled child could be expelled without a hearing as to whether this expulsion was related to the disability. The court issued an injunction and readmitted S1. The district appealed. The Fifth Circuit Court of Appeals held that intellectually disabled children may not be expelled without a determination hearing. And so this case is what initiated the whole manifestation determination hearing when you have a student that is suspended or when you have a student that is disciplined. A child with disabilities can't be expelled without this manifestation hearing and determination. Cannot be. And of course, this due process procedural protections accompany this. And the IEP team have the responsibility for making the determination based on the relationship between the misconduct and the disability. Schools cannot circumvent the child's right to an education and the LRE. The Honing v. Doe case also it focuses on two emotionally disabled students who were suspended for less than 10 days, one for physically assaulting a fellow student, the other for making inappropriate comments to a classmate. The school district scheduled expulsion hearings for both students and extended their suspensions indefinitely pending the outcome of the hearings. The suit was filed on behalf of the students alleging due process violations, and the Supreme Court held for the students. The court ruled that school officials may not exclude children with disabilities from school in excess of 10 days without implementing due process procedures consistent with IDEA unless there's evidence that the student poses an immediate threat and safety to others. So Congress, in passing this, clearly intended to strip schools of unilateral authority they have held traditionally in excluding disabled students. And so the language in the stay put provision, as this is called, is unequivocal while proceedings are pending. Schools may use their normal procedures where the child poses a threat to himself or others. Districts can temporarily suspend this student up to 10 days without a determination hearing in cases where there's an immediate threat, but the manifestation determination has to be made according to IDEA within that time period. So the suspension and behavioral issues can be very challenging, particularly for students that have a disability that is a behavioral-oriented disability. Lastly, we want to talk about Section 504 of the Rehabilitation Act. You refer to 504 plans in your school. That is a reference to this particular bit of legislation. It's important to note that unlike special education, which is administered through all the workings of the government through the Department of Education, 504 actually comes from the Office of Civil Rights, because this Rehabilitation Act is something that applies through civil rights law, and it prohibits the discrimination against individuals with disabilities throughout. So this applies to students, but it also applies to your staff equally. There is no federal funding attached to Section 504, unlike IDEA, where there is federal funding and state funding that's attached to those students and serving them. It does require a district to provide the free appropriate education and to qualifying students regardless of their disability. And of course, many of you have worked with this. You know that these can be physical, mental disabilities, which limit one or more life activities, including things involved with their regular affairs like going to school. This can range the gambit from some of the attention deficit issues to test-taking issues to students that have had alcohol and drug problems. So there's a whole wide range of things. It's separate from special education programming, but it does also fall under the need for providing FAPE, particularly for those who have disabilities or who have things that restrict them from in being involved in normal life activities.